Hi everyone, it's James from Community Legal Centres Queensland here. I'm here with my colleague Rosslyn Monro, and we're going to be talking a little bit about the fantastic experience that both of us had doing Churchill Fellowships over the last couple of years. Before I start, can I acknowledge the traditional custodians of the lands from which we're broadcasting today, the land of the Yagara people. We acknowledge them as the traditional custodians of this land. Pay our respects to elders past and present. And to any Aboriginal and Torres Strait Islander people who might be joining us today, welcome. Can I also acknowledge the traditional owners of the lands on which, from which you're watching us, which is actually all across Australia, which is fantastic. So we acknowledge that we all live and work on Aboriginal and Torres Strait Islander land. This is quite a different format to what we're used to doing in our webinars. It might fall flat on its face, or it might be amazing. We love your feedback on how it goes. It's a bit more almost fireside chat, the fireside being the Community Legal Centres Queensland banners behind us, where we thought we'd just have a bit of a conversation about the experiences that we had over the last couple of years as Churchill Fellows. Given that it is a different format to what we're used to, feel free to chip in with questions as we go. You can ask questions in two ways. You can press that button that looks like a hand on your control panel. We'll see something that looks like a hand going up. You'll be able to unmute your microphone and you'll be able to ask a question that way. And the other way that you can ask a question is to type a question into the questions box, and we'll be able to read it out, peering into the screen probably, which might be a little bit weird, fish-eye kind of camera stuff. Yeah, we'd really like this to be more of a conversation than just talking at you. I think that's the housekeeping type stuff. We're also going to try and record this, so you might be able to catch up on it on demand or something like that. So it's going to be kind of a weird semi-interview, stilted conversation style, but we think we've got plenty of interesting stuff to talk to you about. Rosalind, can I just start with you, and it's deviating from the script a little bit. Churchill Fellowships, what is it? What is a Churchill Fellowship, and what did it actually mean practically for you?
So a Churchill Fellowship is an opportunity to apply for grant funding, I guess, to explore a topic that you mightn't ordinarily be able to do domestically. So at the heart of the Churchill Fellowship is the need to travel outside Australia to explore your chosen topic. And I guess it had its provenance back in the day when Winston Churchill passed away. He was a great favourite of Australia, and they had this national fundraising campaign around the country, and just mums and dads donated to the trust. And they set up this scheme where people from all walks of life could apply for grants to do this sort of travel, to bring back ideas to Australia to enhance our society, because they saw Winston Churchill as sort of an everyman, Renaissance man. He had a diverse set of interests, and so they didn't narrowly confine the trust to a particular area or topic or people. They wanted it to be a really open opportunity for Australians to explore topics outside their own country. And in the 60s, pre-internet, there was a lot of travel outside, and it was for long periods of time. So some people went for 6, 12 months to live overseas to study. Now it's a little more punchier. It's sort of more likely to be 6 to 8 weeks that you travel.
And what was the issue or the topic that you wanted to explore when you applied for your Churchill Fellowship?
So I looked at funding diversification for community legal centres, and the reason why I chose that topic is that it was a very central topic to kind of my career in some ways in community legal centres, because I've been managing centres for about 16 years, and the constant headache for me as a manager of community legal centres was balancing the budget and having enough money to be able to do the work that you want to do. And, you know, as many of people are well aware, we do have even a greater funding crisis currently in terms of government funding. And so I saw this topic as being a really clear way of exploring what might be open to us in the future. How about you? What was your topic?
So I was a bit taken at the time when I did mine, which was about 3 years ago, on the idea of community organising, and I think it was a bit of kind of Obama love and that kind of stuff. So having seen ways in which in the US lawyers can work in community organisations or as community organisers to affect change. One of the key experiences that I had that had led me to that point, some of you will know that I used to manage the Homeless Persons Legal Clinic in Melbourne, and the state parliament was conducting an inquiry into public housing, and I went along with one of my colleagues to speak at one of their hearings and talk along a couple of people who were tenants in Victoria's public housing and who'd had some really different experiences. So my colleague and I talked about kind of casework trends and numbers and what we'd seen in our casework. The committee then moved in camera or allowed the tenants to give confidential advice because they were a little bit concerned about being victimised if it came out that they were telling their story about their experience of public housing. Two really different stories. One woman been homeless for about 25 years, experienced all kinds of trauma, moved into public housing, was able to finish high school and through an equity program go to university, was a Dean's List Scholar in her first semester, and talked about public housing being the basis for her to move into that part of her life and really start to achieve some things that previously she never thought she would. The other client talked about her experience in public housing. She had a disabled son. They both had a long history of domestic and family violence. They were in high-density housing, which they felt was really unsafe for them, and she felt was particularly unsafe for her son. And the public housing experience kind of exacerbated the trauma that she experienced over a long period of time. And so I was listening to these two amazing women tell their amazing stories and looked across the table and literally saw members of Parliament in tears. I've got no doubt that that was the most effective piece of changing the hearts and minds in a law reform kind of sense that I'd experienced as a community lawyer. And that really confirmed for me that while we have an important role to give voice to our clients, to provide a platform for our clients to have voices, that part of our work was a little bit underdone and could be incredibly effective. And so I wanted to see how those kind of community organising models and the empowerment of communities, and particularly those communities affected by bad laws or bad legal systems, could be supported or enhanced through the work of community lawyers. So I went to the US, the UK and Canada to look at kind of different models there. So my trip took me to Los Angeles, San Diego, New York, Chicago, Toronto and London. I'll talk about each of those in a little bit more detail. But in San Diego, I was at a conference for the National Alliance to End Homelessness. And in Chicago, I did a week's community organising training with the Midwest Academy, which were kind of two centrepiece pieces of work there. I also spoke to about 50 people in those cities to get a bit of an understanding about how community lawyers and community organising principles could work together a bit. Which cities did you go to?
So I was only in the US. Unfortunately, my topic only kept me in one country, which is a great tragedy of my topic. But anyway, I went to Los Angeles, San Francisco, Seattle, Washington DC, Baltimore, New York City, Boston and Chicago, and I centred the travel around a couple of key conferences. One was a more general fundraising conference in Seattle for not-for-profits and charities across the board, and the second conference, which was in Chicago at the end, was a fundraising conference for exclusively for legal services. So, and I had focused on legal services and also had some fantastic one-day masterclass training around the messaging about legal services that was run by Voices for Civil Justice, which I can talk about a little bit more later. So for me, the need to travel to those cities was about looking from afar and seeing who might have been doing well in the space of funding diversification and going and having a chat with the services that were doing it. So there's no surprise that the services that were doing really well were along that east and west coast of the US. But the conferences gave me a good chance to catch up with people around the country, and there were certainly some very strong themes across the work, and there were variations depending on geography, but I guess I found that funding diversification for what are called civil legal aid over there, which would be the equivalent of community legal centres in some respects, were that they had a similar sort of strategy and were having similar conversations around the country. So there wasn't a huge diversity in how it was being approached. It was sort of the level at which it could be done or the level at which it was resourced.
And so given that you were in the major cities, and I found these two being in the major cities, again deviating from the script a little bit, but you made an observation that as far as your work was concerned, probably limited relevance for centres in Queensland in RRR areas.
I think it does perhaps require us to think about our own context and not just transplant ideas internationally and put them into the local setting. I think there's lots to be learned, but we do have a different set of challenges. And for me, the big set of challenges in funding diversification, which is basically, you know, trying to find private sources of funding, is in Australia we don't have a very robust philanthropic culture, and that's got something to do with the concentration of high net wealth individuals, but also about how we think about giving in Australia. So I think there is a much greater tradition, rightly or wrongly, because I think there are some good reasons why this is the case and some bad reasons why this is the case in the US, about the need to contribute and having even a family culture of giving in a cash sense, particularly in the US, that we don't have here. And certainly it's borne out in the sort of overall figures that you compare the US to Australia. The rate of giving is substantially lower in Australia, even if you kind of take into effect that our population is so much smaller.
I think that point around the context, the differences in context, is one I'd like to explore a little bit. So I was struck by some of the funding arrangements and the impact that that had on some of the contextual points. So the Legal Services Commission is a corporation, is the central federal government body that allocates funding to civil legal aid services, and they distribute between $350 and $400 million nationally each year. Although it's been said or suggested that that'll be one of the programs cut by the new president in his budget blueprint. But in the mid-90s there was some pretty significant, and that stemmed from part of the war on poverty, so those funded organisations have been around for 30 or 40 years. In the mid-90s there were some significant changes to the way that recipients of that kind of funding could operate, in that if you received that funding you couldn't engage in any what we would call law reform work, but it explicitly excluded community organising, but any other form of advocacy. So there was a real demarcation I found in US civil legal aid services between those that received legal services corporation funding, which were kind of your high volume bread and butter CLC kind of equivalent, but that was not in any way really engaged in law reform work. They tried to use other arrangements to do that kind of work, so partnering with community organisations. Some of them working in partnership with kind of sister organisations with the same board that could do some advocacy work. But generally speaking, they were kind of the bread and butter CLC, what we would see particularly in our generalist services here. And then there was a kind of separate class of services that relied on independent funding. So whether that was from state or local governments, or more likely the kind of organisations that you were particularly interested in your fellowship, Rosslyn, organisations that independently fundraise through philanthropic grants and donors. And they were able to do a lot more, act a lot more flexibly and do different and innovative things. Some of them had lobbyists that they employed that were based in state capital buildings. There were all kinds of campaigns and really active campaigns there. One of the downsides, I think, was because they were so reliant on alternative sources of funding, and particularly fundraising, there was a tension there when they sought to engage in partnerships, because they kind of needed to be taking credit for all of the work of a coalition or a movement so that they could impress their funders and build their base, build their fundraising base and their supporter base. And that kind of mitigated against, in some cases, constructive, collaborative partnerships with other organisations, particularly in some cases, those organisations funded by the Legal Services Commission. So I think that funding restriction that came in 95 or 96, as I understood it, had kind of wholesale impacts on the type of work that organisations were doing, the way in which they partnered with other organisations, and their preparedness to engage in alternative forms of fundraising. And I think that came through a bit in your report too.
Yes, although not so much in terms of I didn't see much evidence of the two types of services radically changing their fundraising strategies. So I think across the board there was some similarities, irrespective of whether they received LSC funding or not. I think the one area that had the greatest distinction in the fundraising strategy as such was in Washington State, in Seattle, where they had a very proactive bar association that they basically used the bar association as a clearinghouse for what we would know as interest on sources, trust accounts, that sort of money. And so that bar association then restricted the ability for organisations to do direct appeal to law firms. So the way that services, and in particular service I visited, who was very proactive in this area, could get around that in terms of doing direct campaigning to law firms, is that they would do their campaign as part of an event. So they would run their gala event, and in the lead up to that event, you do a bit more of a direct campaign strategy, and that was okay. So, but generally, irrespective of whether they received LSC money or not, civil legal aid services were very much targeting lawyers and law firms for the lion's share of the private donor kind of strategy, and the other sort of part to what people were doing in this space was, targeting philanthropic organisations and lobbying philanthropics to better support legal services and to help them to better understand the fact that legal services were important in solving the big social problems that philanthropists want to solve, such as poverty and homelessness and unemployment, and how did legal services contribute to the combined efforts to alleviate those major social issues.
So the two target groups that you're talking about there, essentially, for this fundraising work is the private legal profession and a more educated, informed, engaged philanthropic sector. And they're kind of the lessons from the States there. How transferable is that to our context here in Australia, do you think?
Look, I think there are challenges for us where certain, so to bear in mind, I think the organisations who are doing this have been doing this for at least 10 years or more, maybe 20 for some. So we're really, barely out of the starting blocks in some respects in this work. And even compared to other charitable sectors in Australia, we're fairly out the starting blocks. So I think there's a range of challenges for us. It's actually building brand awareness. What does the CLC do, and how do they contribute to the impact on major social issues that matter to people, and to, I guess, know that we don't have a philanthropic culture, and how do we work with that, and also about what we mean by pro bono, which can be a very challenging kind of area for the Australian legal profession to think about. So in the States, there was a very strong culture of the professional obligation to undertake pro bono work, and for some bar associations, this was seen as a mandatory criteria in which you could continue to practice, and is to fulfil your pro bono quota, and you could discharge some of your pro bono quota by cash contribution. So I don't think we're anywhere close to getting to that stage in Australia, and the question is out there still about whether we want to even go there. But there are certain conditions and certain conversations and certain relationships that need to be built in order to successfully do this work on a long-term basis.
One of the, I didn't call them recommendations in my report, let me plug my report, but I had 15 suggestions, I think, and one of them was kind of a 10-year plan to better inform and engage philanthropy around the value of our services. And you put it far more eloquently than I had even conceptualised it, but the role of legal services in contributing to those big social problems, because one of the reflections that I had, and it mirrors yours, although, as I said, yours goes much more deeply into it, was that funders understand the value proposition of advocacy work in the States, or pockets of philanthropy. It's not kind of broadly across the sector, but pockets of philanthropy understand the value of that type of advocacy and representation and legal support for people in a way that, with a couple of notable exceptions, we just don't see here in Australia. And I think it really is kind of a really long-term plan, which is really challenging for us, because often when we think about funding, thinking in terms of short-term funding cycles, possibly short-term electoral cycles. So 3 or 4 years is kind of long-term thinking for us as far as our funding goes in a lot of ways. I think that's a 10 or 15-year project really to better inform philanthropy and givers.
Yes, and certainly I think we've got to, and some of the change has to happen with us too if we want to go there, because I think you can, in the area of funding diversification, get really hung up on the transactional nature of the work. So, so you're thinking about obtaining the funds by giving the other person or entity something. And I think if we stay in that transactional raffle ticket selling kind of mentality, it won't go anywhere, because what it was very clear to me is across the board that this is relationship work, and that you at least need to invest 3 years in relationship work before you see the transactional side of it starting to kick in, and which is return on investment. And so, this is not sort of, okay, we're going to hold a fundraiser of some sort, whether it be a private donor campaign or an event or whatever your tactic is, unless you have that relationship and the investment in continuing to develop the relationship, you will not see the return on investment.
Spoken a couple of times, Rosslyn, about events, whether it's in the context of using that as kind of a workaround for funding clearinghouses or as other things. And I know in a previous role you've worked in organisations that have used events as fundraisers on field bases, but your reflections from the States add a bit of nuance to that maybe?
Yeah, so certainly there was a strong bias against events. Whenever I raise events as a tactic of fundraising with people I spoke to, there's lots of eye rolling and teeth gnashing, and sort of basically saying, you know, they're a lot of work, and in one conference session I went to, basically you can run the numbers to see whether they're actually a profitable return on investment. And if they're not sort of growing at a rate that you would expect, then they may not be a good way of fundraising, but they can be an excellent way of friend raising. And, you know, you can't have one without the other. And so people were still doing events. They were doing big gala ballroom things. And, you know, in DC there was an organisation that was, you know, raising $1 million with their gala event in the lead up to the event. And there was no transactional aspect to their event. It was all sponsored. So you couldn't buy a raffle ticket at the event. You know, they brought on their sponsors right at the beginning in the planning of the event, and because it's been going for such a long time, it's such a feature of the legal profession's calendar, that they were able to build it, that it was a significant event in the life of that organisation and for the profession. And I think the big takeaway was if you hold events, you've got to think about what you're going to do after that event, because it's just as important. Because if you are going to keep those supporters and call on them regularly to support the organisation, then you need to have a follow-up strategy. And, you know, in some respects, if you're holding an event and you can't retain those supporters, you have to start questioning why you held the event in the first place.
I'll change tack a little bit and talk about both members and boards. You went into a much deeper dive on this than I did, but my reflection was again, looking at the LSC funded organisations and the independently funded organisations, for want of a better word, had quite different approaches to what their boards would do. So in the LSC funded organisations, there seemed to be a norm that 2/3 of the members would be lawyers and 1/3 would be members of the community who were service users or could be service users because they were on low incomes or otherwise qualified for that assistance. I couldn't find anything in any of the LSC documentation, but I had enough people tell me that that was the expectation to kind of accept that as face value. The independently funded organisations, though, there are a lot of them that had absolutely enormous boards who were there to chip in money. So one organisation that I met with had a board of 75 people, and then had an executive of kind of 10, and that was where the governance and strategy kind of decisions were made. But the boards were, and there was an expectation that of those 75 people, I forget what the figure was, but maybe it was $20,000 or $30,000, that each of them was expected to either contribute themselves or bring in a friend or kind of tap their circles for that kind of giving. And that idea of fundraising boards isn't something that we've kind of contemplated at all here in Australia. I think increasingly community legal centres are looking for a skills-based board that will include people who have some experience in fundraising or some of those other kind of external relationships that can support fundraising work. But I think that idea of the board is, I mean, quite weird for us here. Do you think any of that kind of stuff might be transferable to what we do here in Australia? I think one of the good things about modern governance in Australian not-for-profits is the skills-based approach, because I think governance is not just about the money, and it can be a big part, but it's not the only thing. So I think, I think in my report, the great phrase that is frequently used is give or get. So you either bring some dough or get some dough to stay on the board. And I met services that had quotas for their board members. So unless they could bring in $15,000, they couldn't even be on board. So I think for us, the lesson is to how do we get in a skills-based model some of that expertise into our governance model, and
we do need to be cognizant that if we want to broaden out our reach into the community and our brand, that boards and management committees are really important people in that process. You know, I think if we're talking about management committees being members of the community, which in many community legal centres they are, then we need to think deeply about, you know, how they can bring things to the table that a CLC mightn't ordinarily be able to do. So we do need great supporters, you know, and I think the key for these board members in the US organisation is they were tremendous advocates for the organisation, and it was a very high expectation that they would be advocates for the organisation and were an integral part of how that organisation presented itself and part of the brand and its ability to be known more broadly in the community. So that, I think they're the sorts of things that we can think about and bring to our own governance context.
And just reflecting on that, when I was in Toronto, the province of Ontario, I think, has the closest thing that I've seen internationally to what we do here in Australia in our community legal centres, with a couple of important differences. One is that their provincial government, which mainly funds the services, have committed to full geographic coverage. So in each of the local government areas, I think there were 77 or 80 or something like that, there was a commitment that there would be a community law clinic in each of those, or servicing each of those areas. I think we've still got massive black spots across Australia, and so that's not directly relatable. But they have a peak organisation, although they didn't understand the concept of a peak organisation, but an organisation that was called the Association of Community Law Clinics of Ontario, ACLCO. I haven't worked out how to pronounce that acronym, ACLCO. They had an advisory group, which was kind of a table of elders. It was a really interesting concept where Ontario's community law clinic network was championed by a provincial Attorney General called Roy McMurtry, who then became a Supreme Court judge, and now in his retirement chairs this group. And it's kind of senior former politicians and judges and those types of people that, again, coming back to your point, is a different, kind of linking back to your point, is a model that uses really strong advocates to support the work that the movement is doing, and it's had really an invaluable role in interfacing with government, in educating donors and givers, and in raising the profile of the great work that's happening in community law clinics in Ontario, which also historically has a community organising focus across their community law clinics, as they call them. So there's almost an expectation that each of those organisations will have community organising or community law workers, they might call them, but that are quite different to the kind of community development workers that we saw in the earlier days of community legal centres here, and that still kind of permeates the UK law centres. So I think, but it's interesting to think about the role of those advocates. Other advocates can be members, and one of the reflections that I had in my report was, or one of the suggestions was to think about how we use members in our services. And that was reflected kind of in a few ways in my report and my travel. My sense is that in Australia, community legal centres members are generally those supporters, often volunteers, who come and attend kind of an evening advice service or would otherwise assist. You kind of pay, I don't know, anywhere from $2 to $30 probably to be members. Turn up to the AGM, or a handful of them, enough to hopefully meet quorum, turn up to the AGM, get their newsletters or otherwise contribute as volunteers. But I don't think that our current model, I think 30 of our 33 members are incorporated associations here in Queensland, and I don't think that model of community membership really is fit for purpose for what we're doing now. And so in New York, Make the Road is a legal and community organising organisation that requires people to join as members to receive services. And I think that's really controversial, a really controversial way of thinking about things here. They're not charged a fee, but they're required to be members, and that then builds the base for community action and community organising and building a sense of community. So they've got 15,000 members now. They've been around for a few years and are, again, an independently funded organisation. But I think that idea of really consciously thinking about ways that we can build a membership base that isn't a source of income, because for most of us it's actually more of an inconvenience to rustle up those kind of $5 membership payments each year than it represents in terms of any kind of financial gain. But think about how we can use and engage the members of our organisations as advocates or as contributors to social change or the other type of work that we're doing. Rosslyn, I don't think I saw much in your report about the use of members. It was more focused on boards. Did the idea of using members come up much in your discussions?
No, interestingly not. I don't think we talked to members at all. But I wanted to return to your piece around peaks, because what I think we can perhaps capitalise on here that didn't exist in the US in the area that I was looking at was there's no sort of coordination and collaboration. Well, yeah, sorry, I take that back. There was coordination and collaboration, but it wasn't happening in such a sort of organised way that it might happen here. And so they certainly had organisations who were not-for-profits that helped with the communications piece and with the management piece of organisations, and were supportive of that work and do great work. But right at the end of my travel, you know, it's almost like the third last day that I was looking at the topic in some detail, and I found out that the sector, and they probably don't even describe themselves as a sector in some respects, was still having a debate about what to call themselves. So they couldn't agree on a collaborative term to talk about their work. And so I use the word civil legal aid because that is where many see this issue going, but there isn't any sort of, yes, we all relate to being civil legal aid, whereas I think through peak bodies, both at the state and national level, I think the one hurdle we have overcome in Australia is how we identify ourselves, which is a very strong basis on which to build this broader sense of awareness across the community. I think it's not too controversial for us to all to agree that we're community legal centres, and in fact things like NACLAC accreditation kind of creates those, binds us even more tightly together in other ways other than just name as well. So I think I saw something that perhaps I took for granted, that having a federated structure and having state and national peaks to bring us together in some way can be a really useful way of us being able to present ourselves to a broader community.
And I think that was peculiar to the States in my experience. So both Ontario, which has by a very large margin the most sophisticated network of services in Canada, and in the UK there were what I would call peaks, although as I said they didn't really identify with that. In the UK, it's the Law Centres Network, and their Executive Director or CEO is Julie Bishop, who used to be the Executive Director at NACLAC here, moved to London maybe 6 or 7 years ago to take over the leadership of that organisation. And when I visited, which was a little over 2 years ago, it had been less than 12 months since as part of the austerity measures, about 40% had been cut from legal aid funding in the UK. And so they were very much in kind of crisis mode across the sector, but because there was that shared sense of identity and that shared membership, there are a whole heap of strategies that were going on collaboratively to address that. Some examples of that were, and this is something that certainly in Australia there's no appetite for at the moment, the common branding. So they have variations on the same logo for each of their members across the country that identifies that they are law centre network organisations, and in many cases use the term law centre in their name to kind of reinforce that branding. And similarly, another peak in the UK, Advice UK, is the peak organisation or the representative organisation, I think they call themselves, the Citizens Advice Bureau, which kind of have a similar role in some ways to the advice services provided by Community Legal Centres here. In Toronto, again, the Association of Community Law Clinics of Ontario was really only 2 or 3 people, but the director there had been in the role at that stage for 14 or 15 years, and they'd done a significant amount of work together around some of that shared branding. But I think they'd come from a history of working really closely together, in part because of some quite exceptional leaders in the early days of the movement in that part of the world. But I think you're right, the fragmented nature of the movement in the US makes some of that common storytelling and some of that common, we might talk about brand awareness, but that's a pretty trite and commercial way to talk about it, but the real sense of community understanding about the work that happens in our movement is aided where there's that level of cohesiveness and some kind of structural collective leadership, I guess.
So how do you feel like your fellowship really impacted on what you did when you came back?
It reinforced for me the importance of different types of partnerships. So probably 2 or 3 examples of things that I picked up through my fellowship that where I've started to plant some seeds here in my work. One is research partnerships. I think I went particularly to the States expecting that they do things in our area a lot better than we do. And I don't think that's true in any sense. Well, it's probably true in some senses. But generally speaking, I think we do as well in terms of our provision of legal help to disadvantaged people of the community who otherwise wouldn't get that help, as happens elsewhere. They just tell the story a lot better, generally speaking. And a big part of that is through a canon of legal research that kind of just tells the story of a particular housing rights student clinic or the experience in a immigration law clinic in some parts of the South. They tell the story better in part because they have stronger relationships with researchers and academics whose role it is to delve into and critically analyse the work that's happening. And so probably half a dozen of the people that I spoke to in the States were researchers who'd work, in many cases whose work would come across here. So I think forming some of those relationships is really important. And so about in May or June of last year, we held our first research roundtable with kind of a mix of community legal centre people and academics in the room. There were about 50 in the room to have a conversation about ways in which we might build stronger research partnerships. And it's great that our national association, NACLAC, is picking up some of that work to develop a national research agenda in partnership with community legal centres and state and territory associations and academics. And similarly, the Department of Justice here, we're having a conversation with them about developing a legal assistance research strategy, which might guide some research locally here in Queensland. I guess that's one example. What about you?
I changed jobs.
There
you go. So I think, but I think for me, probably because I haven't been back as long as you have, that's my excuse anyway, is thinking about the lens through which I see the work of community legal centres, and to perhaps see how particularly we talk about our work in a way that translates much better across a broader community perspective. And I think it's when we're going through, a funding crisis, I think bearing that in mind is important, not only to speak to the politicians, but to also you can see that we need to continue to build the community awareness about the value of the work. And I guess I came back with some tools that helped me think about that a bit more constructively, and particularly about how you might do that, and running that through the sort of values framework that we need to perhaps link into with the broader community. So if we want to convince people outside our organisations about the value that we do, then we need to connect with their values as well and speak to those. And I don't think we've necessarily done that a whole lot in the past. So certainly bringing a different lens to how to think about it, and particularly now working in a state peak as opposed to being in an individual centre, seeing the broad spectrum of work that community legal centres do and how we might translate that. We don't want to water down the diversity of the work that we do, but we also need to be clear that we've got to start the conversation some way, and you need to find a cut-through shared value that's going to do that.
Rosslyn, it looks like we've had our first question come through. While I reach over, I'll just remind people that there are a couple of ways that they can ask questions. One is to press that button that looks like a hand on the control panel, and we'll be able to see your hand go up, and we'll unmute your microphone and you can ask a question that way. The other way is to
muted.
Sorry, I think our sound. Sorry, I think our sound might have dropped out there. Can I just get people to press that hand button to make sure that we're back? Terrific. There's a whole heap of hands going up. Thank you, and I apologise for my technical ineptitude. So that should be right now. So I'll just repeat the questions that have come through from Janet, and fantastic to have that question, or those questions. We'd love to have more. Did you see any differences between generalist and specialist centres? Did the places you visit have specialist centres? Did you see any examples of centres who did criminal work, or is civil legal services overseas only about civil work? So I might use some examples to talk about specifically there, and then take it to a high level. Columbia Legal Service was based in Seattle, and I met with their, at the time, senior child rights lawyer. They had 4 programs, one of which was children's rights, at the National Alliance to End Homelessness conference that I was at in San Diego. They do engage, so it's a youth law service, and they absolutely engage in assisting clients through criminal processes. Network of public defenders do a bit more of that, so there were probably niche areas that this service operated in, particularly in child protection areas. Given the amazing demand, one of the comments that came from that organisation, which kind of caused me to reflect a bit, was ordinarily they would only engage in civil litigation if the impact of that litigation would assist more than 100 people. So, I mean, class actions and the way in which kind of a lean towards or a dominance of litigation processes as legal tools absolutely permeates a lot of the organisations that I visited in the States. But I thought that that was really interesting because of their limited resources. They'd only engage in civil litigation that was likely to affect more than 100 people. I think there's that fundamentally challenges some of the values that we have in community legal centres here. If you stop and think about it, it's actually a sensible use of the limited resources that we have on one level. I'm still very challenged by it, but I think there's some ideas in thinking about if we're going to take on casework, given that only about 7 or 8% of the work that happens in community legal centres in pure numbers is casework across Queensland, thinking about how we can use that casework to its maximum effect is really useful. Public defenders' offices, and I visited a couple of them, were generally funded by state or city governments and generally provided legal help in criminal law matters. And they were, generally speaking, quite different to those organisations that I visited that were Legal Service Corporation funded equivalents of our community legal centres here. So generally speaking, they didn't do criminal work, but some of the work that they did was quasi-criminal. In my naivety, I didn't understand the impact of immigration law issues in the States and how much of a focus that is for their legal assistance services generally. I'd say from what I saw, it would probably be the #1 focus across the network. And a lot of the situations in which they're representing individuals in that system is a quasi-criminal kind of process through the immigration courts. And so absolutely there are lots of examples where that happened. In terms of the difference between generalist and specialist centres, absolutely. The generalist centres that that particularly resonate with me were in Los Angeles, where there was the Legal Aid Foundation of Los Angeles and the Neighbourhood Legal Service, both of which I think had 3 or 4 offices. They organised themselves in a lot of cases in terms of programs, because I suspect that the Neighbourhood Legal Service had over 100 staff in their 3 offices. I suspect the Legal Aid Foundation had north of 40 or 50 in the office that I visited. So because of their size, they kind of had to organise themselves somehow, and so they organised themselves programmatically. But I would describe the work that they did as generalist. In Canada, it's kind of different. So as I said, there was full geographic coverage, so they absolutely have generalist services. But when funding came in, I don't know, more than a decade ago, for additional specialist services, established 2 specialist services, one that dealt with social security and one that dealt with tenants' rights. Rather than those services being high volume advice services, which is by and large what we're used to seeing in specialist tenants and welfare rights services here in Australia, the sector, and because they were a cohesive sector, agreed that those services should focus on capacity building of generalist services, on community legal education and law reform work, and on impact litigation. And they do lots and lots of impact litigation relative to what we're used to seeing here, although Canada, I suspect, isn't anywhere near as litigious in terms of its community lawyering as the US, much closer to us. But that's their absolute focus, is that impact litigation, and generalist services, as we would call them, would continue to do lots and lots of social security and tenancy work. Some of the ones that I visited would be north of 80% of their work would be in those 2 areas, despite the fact that there are well-resourced expert specialist services. Less so in the UK. I think their law centres network, from what I saw, and I didn't visit many of them, probably only 2 or 3, but from what I saw, they were very much in that kind of neighbourhood legal aid office model that kind of gave the genesis to our movement. The specialist services probably wouldn't describe themselves as law centres, so they'd be organisations, national advocacy organisations like Liberty or Shelter, or those types of organisations that, just wouldn't perceive themselves to be part of this movement, but would absolutely be providing individual advocacy and sometimes individual court-based advocacy for those people. So it's a little bit different there. What about you, Ros? Specialist and generalist services and criminal work?
Yeah, I probably didn't interrogate the models of service delivery quite as heavily as you might have, James, because it sort of wasn't, it was a bit off topic for me. But certainly I went to what we call special centres in the US. One specialised in immigration in Seattle, and they were a really impressive organisation, and some of the work that they've been pumping out around the messaging about what they do is really great. And I also went to a couple of services that specialised in providing services, legal services to women. So for me, what was interesting though is, and again, I didn't interrogate the model as heavily as I might with a different topic, but my sense of them in terms of the specialist, generalist division, or even model across the board is that there wasn't perhaps the level of integration across professions that you might expect in, say, a community legal centre. So my sense is that, the vast majority of the employees at the centre were legal staff or staff supporting the legal work, and there wasn't necessarily a whole lot of additional other social services integrated into the model. Maybe it was just the kinds of services that I was walking into as opposed to it being a feature across the board.
Certainly I did visit services that were a bit more integrated in that way, and The Door was one of those in New York City, which is essentially a youth drop-in centre, I guess, that had a whole heap of support services, the legal office, which was on the second floor with 3 staff. But when I got there, there would have been, I don't know, maybe 60 or 80 young people in the building. I actually got there when the police had been called to deal with a particularly troublesome visitor. But it was really clear that they were a really integrated, almost a health justice partnership, as we are starting to call them now, where there were health services on the side, there were education services, but really it was just a drop-in centre for people, the young people who weren't particularly safe at home. We're starting to get towards the end of things. Ros, another question's come through. How do CLCs connect with key government makers in decision who seem disconnected? Is the question. I guess in terms of, we've got all kinds of crazy things we could say about our own key decision makers here in Australia, but let's hold that for another conversation. In the States, I guess the absence of a national movement made it a little bit difficult. It didn't feel as though there was anyone speaking with one voice on behalf of what we would call community legal centres. A few organisations tried, and NLADA, the National Legal Aid and Defenders Association, would be one. A lot of it was done, a lot of what I saw done in terms of law reform or speaking about funding to decision makers happened at a state level, and so a lot of the organisations had built good relationships with state elected officials more than, I think, national elected officials, which was kind of interesting. As I said before, one of the centres I visited, the Western Centre on Poverty Law, which was based in LA, employed 2 lobbyists who were based in the state capitol building in Sacramento, I think, is that right? And so they very deliberately sought to build relationships as genuine lobbyists, which was kind of, I found really quite strange. But they could point to a whole heap of legislation in terms of law reform that, in fact, had been drafted by their staff solicitors or staff attorneys and shopped around by the lobbyists because of the relationships that they had which is, again, quite different. So I guess the couple of key messages that I have in response to that question is, in the absence of a joined-up cohesive national sector, it was made very difficult. Where I saw it work well was particularly with sub-national governments, particularly in the States.
From my experience, I think there's two observations, and again, maybe sort of a topic that I didn't interrogate at any great length because I was interested in the non-government stuff. But first and foremost, I think the services I looked at probably relied on their board to have those relationships with government. So that might have been a key feature of appointing a particular person to a board. And, you know, they were chock-a-block full of lawyers who probably went to law school with the decision maker, and it was all relationship-based type work. And even one of the services I dropped into Boston, you know, one of the staff members had an ongoing relationship with Hillary Clinton's running mate at the time, and because he'd grown up in Virginia, and so, you know, what I saw from my perspective very much based on the interpersonal relationship side of things. And the other more systemic work I saw was the Voices for Civil Justice work, which was about herding the cats and getting some key messaging out. And they had some great strategies, and CLC Queensland is bringing one of their trainers out for our conference, big plug, which will be fabulous. And, you know, they would think about who's the best person to deliver this message. So if we're going to get have an opinion piece published in the New York Times about the value of this work, who's the best person to do that? And it's not necessarily someone who's doing the work. It might be the key influencer of the influenced. And so thinking very strategically about what are the degrees of separation in relationship about who's delivering the message to the decision maker.
Terrific. Thanks for those questions, folks. They were great. And I'll finish off. Rosslyn, you've got a list of questions there. We've got about 2 minutes left. What question should we throw out to finish this thing off?
What was the best off-topic finding of your travels, can we say, as opposed to the
Maybe leaving aside my trip to Legoland with my then 4- and 6-year-old. I forget who I was meeting with, but they suggested that I go and talk to a fellow called Dan Fleming in Los Angeles, who was the director of an organisation called the Economic Roundtable. And he was an economist and urban planner, and his little NGO, about half a dozen people, was full of economists and urban planners. And they did a whole heap of really interesting work around kind of building business cases for some of the things that we were talking about. And it reinforced for me, in a way that I'd not really thought about, with that level of depth, what a fantastic resource that was for civil society in that community to better understand, articulate, design, all those kind of things, solutions to social issues with a skill set that they didn't have. Here, I think we struggle with that kind of stuff. I think the closest thing possibly here in Australia is the Australia Institute, which brings kind of that economic analysis, but is kind of pretty clearly and overtly a progressive organisation or a left organisation. I think the strength of this organisation was it was very clearly non-partisan and non-political, but brought that frame to support community initiatives, and something I think would be great to see here that we just don't have at the moment. What about you? Your weird and wacky one?
Mine's less highfalutin. I really like eating bagels in Central Park. But aside from that, I think if you're visiting Seattle anytime, go to the Bill and Melinda Gates Visitor Centre, because it will just blow your mind. I think it really summed up for me the level of philanthropy that is in the States that we don't have. I mean, there's millions of dollars just went into this centre, and the type of engagement, I walked through a series of various ways of engaging people with, you know, what their heart stuff is and how they might give. And despite all of the money that was pumped into that, I thought it was really well done, and I think provides a really useful snapshot of where philanthropy is at in the US by comparison to perhaps Australia.
Yeah. Terrific. A whole heap of, for us, really interesting experiences. Hope you found them really interesting too. We'll, if the technology allows, we'll email around a link to the video, although both of us are so self-conscious that we probably won't want to. We'll also email around links to our Churchill Fellowship report, links to the Churchill Fellowship website. There's about 2 or 3 weeks left to apply for the next round.
If I can get one, anyone can. Is my tagline there.
Absolutely. And really, people working in community legal centres should always have a lock on 1 or 2 of those each year. I think we've got an amazing story to tell, amazing things that we can learn from other parts of the world and bring back here. And everyone in the sector is doing such amazing work that it would just make sense. Thanks for tuning in. We look forward to speaking to you soon, and goodbye.